Good evening, my name is Zara Ahmed and my student number is 1156168. I'm here to advise you, Ali, whether you are entitled to the redundancy payment owed at by HPC Limited. I've taken a look at the facts that you have given me, and the issue to be discussed here is basically whether you are an employee or whether you are self-employed. Because in order to be entitled to the redundancy payment, you must be classified as an employee. Section 230 of the Employment Rights Act 1996 defines an employee as an individual who has entered into or who works under a contract of employment. Now, this is an extremely vague definition as it fails to define what is meant by a contract of service. Therefore, we must take a look at the common law tests which have been provided to us. Now, the original test used by the courts was the control test. Now, under this test, one is an employee if that person is subject to the employer's commands. Now, in the case of Performing Rights Society and Mitchell and Bokar, McCarty Justice suggests that the final test lies in the nature and degree of detailed control of the person alleged to be a servant. So, we must see whether HPC Limited designates your actual work, the hours you work, place of work, and how exactly you perform the work. And these factors were also laid out in Short and Henderson Limited. Now, this basically means that the more under the control you are of HPC Limited, the more likely you will be classified as an employee. Now, further, this does not even have to be everyday control as seen in the case of Walker and Crystal Palace Football Club. Now, you are obliged by HPC Limited to wear their uniform, you must attend their showroom once per month, and you must inform them if there is no substitute available. Now, this shows that you are not free to come and go as you please, which should have been the case if you were self-employed. However, HPC Limited may argue that there are no set hours given. However, this is only just one element which shows that some degree of control is present. Now, as a single test, this test was inadequate to see whether a person was an employee or not. So Lord Denning, in the case of Stevenson, Jordan and Harrison versus McDonnell and Evans, developed the integration test. Now, this simply looks at the degree to which you are involved in the organization. So, the services provided by you must be integral to the organization rather than viewed as a separate business. Now, you're a salesman for HPC Limited and you provide them with the final clients, which means that the source of income is generated via you, which shows that this is pretty integral. However, HPC Limited may argue that you are just a salesman, therefore you're easily replaceable, and whether being a salesman is a skill is debatable. This would probably depend on how good you are at your job and how many customers you provide to HPC. Now, the next test that I will take a look at is the economic reality test. Now, this test basically deals with the economic practices of the individual. This means that basically, if the individual has ultimate responsibility for the profit and loss of the organization, this will show a self-employed situation. Now, the factors to consider were set out in Market Investigations Limited and Minister for Social Security, and they included financial risk, can you hire and fire, and whether own capital was used. Now, as you pay your own tax and national insurance, further you give gifts to customers out of your own pocket, this all shows self-employment qualities. However, none of these are conclusive, and also they do not classify you as being self-employed because you're not exactly in business for yourself but rather for HPC Limited, and you don't exactly have any business responsibilities except to convince the customers. Now, lastly, I will take a look at the multi-composites test, and this was laid down by McKenna J in the case of Ready Mix Concrete versus Ministry of Pensions and National Insurance. Now, there were 3 conditions laid out in this, and the first of which was personal service, because whether the existence of whether you can send out a substitute is vital, and this was explained in the case of Express and Echo Publications versus Tantons. However, in the case of McFarlane and Glasgow City Council, if sending out a substitute was limited, there may still be a chance of you being an employee. Now, you can send out a substitute, however, you must inform them if you're not able to. This shows that there is a certain degree to personal service present. Second element is control to a sufficient degree. Now, this was demonstrated in the case of Whittaker Pensions and National Insurance. Now, as I've discussed earlier, there is control present to a sufficient degree as regards to your uniform and monthly attendance. Now, lastly, are there provisions of the contract which are consistent with it being a contract of service? Now, although it's not stated whether there's a contract present between you two, however, we can see that there's some sort of contract present with some sort of specific terms indicating employee status. Now, lastly, I will quickly take a look at mutuality of obligation. Now, there are two elements to this which must be fulfilled. Firstly, there must be a contract. Now, again, it's not clear whether there's a contract present. However, we can see that HPC Limited is obliged to offer you work which you must accept, as seen in the case of Wilson and Circular Distributors Limited. Now, the second part to the test is future obligation to employ and to be employed, as seen in the case of Hall and Lorimer. And this points to being an employee. Now, you have been employed by HPC Limited for 2 years, since 2011, which suggests an ongoing contract rather than an ongoing umbrella contract rather than multiple contracts every time there is a lead. Now, the fact that you can set your own hours, you pay your own tax and national insurance, you can also send in a substitute, and you also give gifts to customers out of your own pocket. This shows quality of you being self-employed. However, because none of these are conclusive, if you can prove that HPC Limited has a sufficient amount of control over you, and also the fact that you must attend their showroom and wear the uniform, then you can prove that you are an employee and therefore entitled to the redundancy payment. Because just because HPC have said that you are self-employed, that does not mean that that is the case, and this was demonstrated in the case of Ferguson versus John Dawson Limited. Now, in the case of Withers and Blackwell Health Supporters Football Club, it was said that in difficult cases such as this one, a simple question of "are you your own boss" should be asked. Now, we can see that this is not the case here, and this is because you are working under them, and also the fact that you would have no work if it wasn't for HPC Limited. Also, HPC Limited do control your pay because they have control over the customer contract, and they can alter the final price, which results in reduced commission for you, which basically means reduced wages. So it means that they do have control over your pay as well. So this basically means that you are simply not your own boss, and you might be likely to be considered an employee. Thank you. Hope that helps.